Hello visionaries, welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. So last week I talked about what to do if someone steals your digital content. And the short answer is you can send them a DMCA takedown notice in accordance with the Copyright Act. But what happens when you're the one that's accused of stealing and using someone else's copyrighted work, and you receive the DMCA takedown notice? If this has ever happened to you, type DMCA down in the comments. The good news is that you have a few options. So let's jump right into it.
My faith rising. I'm crawling out the trenches, holding me.
First, let's talk about what does it mean for you to receive a takedown notice. A DMCA takedown or takedown notice is a request by a copyright owner to an online service provider to have material that infringes on its copyright protected work removed or disabled from a website or other online platform. If you receive this type of notice, this is not a lawsuit and you're not being sued yet. This is just a notification stating that whatever content that you're using or that you've posted online is being claimed as unauthorized and is going to be removed or disabled. So what do you do in that situation? Well, you have two options. You can do absolutely nothing and let it ride. Or you can send a counter notice requesting that the service provider either repost or re-enable the content that you posted. So let's talk a little bit about the counter notice. A counter notice is a response to the takedown notice to state that the content that was removed or disabled is a mistake for whatever reason. Reasons could range from you being misidentified as someone else, you claiming fair use to the copyrighted work, or you claiming joint ownership and having copyright protection in the same content also. If you're not familiar with fair use, you can check out my video on how fair use works for copyright law. I'll link it down in the description box below. But once you send a counter notice, the service provider must inform the person who reported you and must repost or re-enable that content within 10 to 14 business days, unless the person who reported you shows that they're already filing a lawsuit against you. So what does a proper counter notice require? A proper counter notice must include proof or evidence of the content that was removed or disabled, the website URL where the content was originally posted, a statement under the penalty of perjury that you have a good faith belief that the content that was removed or disabled was the result of a mistake or misidentification, your contact information, a statement that you consent to the jurisdiction in the federal district court where you live, basically saying if the other party files a lawsuit against you, you're willing to come and defend yourself in court. An agreement to accept to be served with the lawsuit paperwork if the other party files a copyright infringement claim against you. And of course, your signature that binds it all together. If you need a DMCA counter notice, I got you. Click the link in the description box below. Go to the TLO Marketplace and purchase a template letter that meets the legal requirements for a DMCA counter notice. So now, who do you send this notice to? So that part is kind of easy. You're going to send the notice back to whoever you got the notice from. So now let's go ahead and wrap this all up and put a bow on it. Generally speaking, either you're being informed that your content has already been removed or disabled and you do nothing else, or you remove the content because you realize that you've used it in an unauthorized way. So what do you do if you receive a DMCA takedown notice? Number one, you do nothing because the notice is informing you that the content that you've posted has already been removed or disabled. There's nothing more to do. Option number two, you've received a notice that is directly requesting that you either remove or disable some content that you've posted, and you follow the letter and remove or disable the content. Or number three, you gather copies of the posted material, you head over to the TLO Marketplace and get your template, so that you can send a DMCA counter notice. You send that letter back to the service provider who sent you the notice. You conduct a Google search to see if your content was also removed from Google search results. And if so, you contact Google using Google's counter notification form to get your content reinstated. And then you wait 10 to 14 days for your content to be reinstated. Well, that's all I got for this video. Leave me your questions in the comments. Don't forget to like, subscribe, and share with a friend. Thank you so much for watching. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far. I'ma keep it pushing, yeah. Even made it through the